The morning after my husband's funeral, my two sons divided $20 million between themselves at the mahogany table in the boardroom of the company their father and I had built from a single concrete truck and a dream we couldn't afford. And then one of them slid a tattered manila envelope across the table toward me and said, "Keep this to store your recipes, Mom. You're old now." I want you to understand what was in that room. Not just the money, though $20 million, split into two equal portions and transferred with the efficiency of men who had been waiting, is its own particular kind of statement. But the room itself, the boardroom of Whitmore Construction Group, occupies the entire 42nd floor of a building in downtown Cincinnati that Gerald and I had commissioned in 2003. And the year the company crossed its first billion in annual revenue, Gerald had insisted on the view, a full panoramic sweep of the Ohio River and the Kentucky hills beyond. The kind of view that says, without needing to say it, "We made it. We built something real, and it will stand after us." I had attended every board meeting held in that room for 22 years. I had reviewed financials in that room, hosted investor dinners in that room, sat beside Gerald when he announced the acquisitions that transformed Whitmore Construction from a regional firm into a national enterprise. My name was on the original articles of incorporation filed in Hamilton County in 1979. My signature was on the SBA loan that gave us our first real operating capital. My hands had addressed the envelopes for the first company Christmas cards. And because we couldn't afford a secretary yet, and I worked the late shift and stuffed envelopes at the kitchen table after the boys were in bed. All of that was in that room. All of that history, all of that labor, all of that love. And my son slid a torn envelope across the table and told me to put my recipes in it. His name is Richard. Richard Gerald Whitmore, 51 years old, named for his father, built like his father, possessed of his father's capacity for decisive action, and entirely lacking his father's conscience about who gets hurt by it. He is the elder. He took the lead in this, as he takes the lead in most things, and his brother Thomas, 48, always the follower, always the one who needed Richard to tell him what to think before he knew what he thought, nodded in the way he has been nodding at Richard's decisions since they were children. I picked up the envelope. It was old, not gently aged, not patinated. Old in the way of things that have been stored incorrectly, in heat and humidity, for a very long time. The flap was dried and crinkled. There was no label. It was sealed with a strip of brittle tape that had yellowed to the color of old teeth. It was, in every visible way, exactly what Richard had said it was, a piece of trash. The kind of thing you'd find at the bottom of a moving box 6 years after the move. "What is this?" I said. Richard had already turned back to the papers in front of him. Something Dad had in his desk, probably old correspondence. We went through everything else. And that was the last drawer. "You went through his desk," I said. "We went through everything, Mom." This from Thomas, gently, the way he says things he has been told to say. We needed to be thorough for the estate. "The estate," I said. "The attorneys required a full inventory," Richard said. His voice had that particular quality it gets when he has decided that a subject is closed and is communicating this by the texture of his speech alone. "It's all been handled. You'll have the house, obviously, And the trust Gerald set up provides you with a monthly allowance that is more than adequate for your needs. There's nothing to worry about. An allowance. My husband of 47 years had been in the ground for 19 hours, and my son was explaining my allowance to me. We should probably talk about the house. Actually, Richard said. He exchanged a look with Thomas. The look of men who have had a conversation before this conversation, who are managing the order of disclosures. The Cincinnati property is quite large for one person. We thought it might make more sense for you to consider something smaller. There's a very nice community in Hyde Park. Richard, I said. He stopped. I will let you finish what you need to finish, I said. And then I am going home. I put the envelope in my handbag. I put my hands flat on the table, the mahogany table in the room with the view of the Ohio River that I had helped commission, in the building we had built to house the company we had built together for 47 years. And I stood up. Neither of my sons stood up when I did. I noticed this. Gerald had always stood up when I left a room. It was a habit of his, a reflex of old-fashioned courtesy that I had sometimes teased him about and secretly loved. My sons had not inherited it. I said goodbye. I walked to the elevator. I pressed the button for the lobby. The doors closed. I did not cry in the elevator. I have made it a policy across 69 years of living to cry in private and only when I have chosen to. And this was not one of those moments. What I felt in that elevator was something colder and more specific than grief. It was the particular sensation of being assessed and found negligible by the people you spent your life building something for, of being, in the plain language of the thing, thrown away. I thought about Gerald. I thought about the first time I had seen him at a church social in Covington, Kentucky in 1972, to when he was 26 and already restless with the ambition that would define his life. I thought about what he had said to me 3 weeks before he died, in the hospital room, where the machines kept their metronomic count of what remained. He had taken my hand. His hands were still large, still the hands of a man who had poured concrete and run equipment before he had ever run a company. And he had said, "The envelope, Adele. Don't let them tell you what the envelope is." I had not known what he meant. In the lobby of the building we had built, I opened my handbag. I looked at the tattered envelope inside it. My hands were steady. I thought, Gerald, what did you do? You cannot understand what was taken from me in that boardroom without understanding what I gave to build what was taken. So I am going to tell you, not because I need sympathy. I am 69 years old, and I have learned at considerable cost that sympathy is a comfort and not a currency. But because the truth of what I contributed is directly, legally and financially relevant to everything that happened afterward, and you need to know it before you can understand why. Gerald Whitmore was brilliant and driven and visionary and almost entirely impractical. He could look at a piece of land and see what should be built on it before anyone else in the room had finished studying the topography. He could estimate costs with an accuracy that bordered on supernatural. And he could talk to bankers and to laborers and to city councilmen with equal fluency, finding the register for each without apparent effort. He was, in the truest sense, a builder, a man whose mind naturally organized itself around the question of what could be made from what was available. What he could not do was keep a set of books. What he could not do was manage a payroll, or file a quarterly tax return, or write the kind of clear, defensible contract language that keeps a business from dissolving into litigation every time a project goes sideways. What he could not do was sit still long enough to read the full text of a regulation, or a licensing requirement, or a legal filing, and understand what it meant and what it required and what would happen if it was ignored. I could do all of those things. I was an accounting major at Northern Kentucky University, class of 1975, graduated summa cum laude. I passed my CPA examination on the first attempt in 1976. I had been working for a regional accounting firm in Cincinnati for 3 years when I married Gerald, and I continued working there for 2 more years after we married, until the baby, Richard, came. And after that, I did what women of my generation, with my particular set of skills and my particular situation, did. I brought the work home. For the first 7 years of Whitmore Construction's existence, I was the entire administrative operation of the company. The bookkeeping, the payroll, the tax filings, the contract management, the insurance, all of it came across my kitchen table. I did it at night, after Richard and then Thomas were in bed. I did it on weekends while Gerald was on job sites. I did it sick twice, once with a kidney infection that put me in the hospital for 4 days, and from which I returned to a backlog of accounts payable that had been sitting in a pile on the counter, untouched, because Gerald could not be persuaded to open mail that might contain numbers he would have to deal with. When Richard was 6 and Thomas was 3, I negotiated through Gerald, who was the face of every external engagement, because that was simply how things worked in 1982, a contract with the city of Cincinnati for a municipal infrastructure project that was, at the time, the largest contract Whitmore Construction had ever pursued. I prepared the bid documents. I priced the job. I wrote the project narrative. I worked the spreadsheets until they told the right story about our capacity. The contract was awarded to us by a margin of 11% over the next lowest bidder, and it was awarded because our bid was more precisely scoped and more clearly documented than anything the city's procurement office had received for a project of that size from a company our size. I did not attend the award ceremony. I was home with a 3-year-old who had an ear infection. In 1989, when Whitmore Construction was 10 years old and had crossed its first $100 million in annual revenue, Gerald came to me with a problem that would prove to be the most significant problem we ever solved together. He had been working for the past 18 months, and with an engineering consultant named Harold Pruitt, on a proprietary method for pre-stressed concrete forming that would substantially reduce both the time and the material cost of certain categories of large-scale structural work. The method was, in Gerald's assessment, genuinely novel, not an incremental improvement on existing practice, but a fundamentally different approach, the kind of thing that, if properly protected, could generate licensing revenue from competitors who wanted to use it. "We need to patent it," he told me. "Yes," I said. "I don't know how to do that." "I'll learn," I said. I want to pause here and say something about that phrase. "I'll learn," because it is the phrase that has defined my professional life more than any other, and because it is the phrase that my sons, in all their years of watching me, somehow never understood as the powerful thing it is. There is a certain kind of person who, when confronted with something they don't know, treats the not knowing as a permanent condition, a limit, a reason to hire someone else, to defer, to decide that this particular thing is simply outside their territory. There is another kind of person who treats not knowing as a temporary condition, as the starting point of a process that ends in knowing, if you are willing to do the work of moving through it. I have always been the second kind, not because I was born with some particular confidence or gift. I was a quiet child, a careful student, a young woman who was told often, and in various ways, that her intelligence was adequate but not exceptional. I became the second kind because necessity required it, and then because Gerald needed someone beside him who could fill the spaces his brilliance left empty, and because I was there and I chose to be useful rather than ornamental. So I spent 4 months learning the United States patent process. I engaged a patent attorney, a woman named Constance Alder in Cincinnati, who would become a 20-year professional relationship, and I worked with her and with Gerald and with Harold Pruitt to document the method in the language and format required by the United States Patent and Trademark Office. I managed the application process. I attended the hearings. I responded to the examiner's office actions. There were 3 of them, each requiring detailed technical rebuttals that I prepared with Constance and refined until they were irrefutable. The patent was granted in 1991. It's United States Patent Number 5,024,411. The method was named, in the patent's formal language, the Whitmore-Pruitt Controlled Tension Forming Process. It was registered under 2 names, Gerald Raymond Whitmore and Adele Christine Whitmore. Both names, both signatures, both legally established as co-inventors. I will tell you something about that double registration that I have told almost no one. Gerald had wanted to register it under his name alone initially, not from any intent to exclude me, but simply because the industry convention and the prevailing assumption in the business world of 1989 was that the company principal's name was on the patents, and that was that. Constance had gently walked him through the legal implications of joint invention, that if I had contributed substantively to the conceptual framework of the documentation, as I had, and to the prosecution process, as I absolutely had, registering me as co-inventor was not merely a courtesy, but a legal requirement and a protection for both of us. Gerald had agreed immediately. More than agreed. He had been relieved. Put her name on it, he told Constance. She did the work. That's how it should be. He looked at me across the attorney's conference table with the specific expression he got when he was proud of something I had done, and was also faintly surprised that other people didn't already know it. And as if my competence were a fact so obvious that its existence should already be common knowledge, and the world's failure to have recognized it was an administrative error rather than a systemic one. Over the following decade, as the patent proved its commercial value, both in Whitmore Construction's own projects and in the licensing agreements we began entering with other major construction firms, Gerald and I had several conversations about what should happen to the intellectual property in the long term. These conversations were the kind that happen between people who have built something together and are beginning to think about how it will be managed after they are gone. They were not formal. They were not always coherent. They were the conversations of a marriage, with all the indirection and assumption and unfinished sentences that marriage produces. But one conversation was different. It happened in December of 2015, when Gerald had received the first diagnosis. Not the final one, not the one that sent us to the hospital room with the machines, but the first one, the one that changes the way you think about time. We were sitting in the study of our house in Cincinnati, with the river visible in the distance through the window, and Gerald said, "I've made an arrangement for the IP for the patents. I want you to know it's taken care of." "What arrangement?" I asked. "It's in my desk," he said. "The middle drawer on the right. Don't open it until you need to." I asked him what need to meant. He looked at me the way he looked at me when he was being deliberately opaque, and which was a quality he deployed rarely, and always for reasons he considered important. "You'll know," he said. I did not ask again. With Gerald, some things were answered by time, rather than by conversation, and I had learned over 43 years of marriage when to wait. I want to tell you about the years between that December conversation and his death, because they were not easy years, and because the ease with which some people imagine the lives of wealthy women is one of the particular ignorances I have encountered most often and find most frustrating. Wealth does not prevent illness. Wealth does not ease the specific grief of watching someone you have loved for half a century become smaller in the bed, quieter in the conversation, more deliberate in every gesture, because each gesture costs more than it once did. Or I was Gerald's primary caregiver for the last 2 years of his life. We had professional help, nurses, aides, the resources that money provides, but the center of it, the presence at the center of it, was me. I managed his medications and his appointments and his conversations with his physicians, which I attended every one of, taking notes in the same careful shorthand I had used for board meetings for 20 years. I managed his communications with the company, filtering what reached him and shaping what went back, because he still wanted to be informed and I still wanted him to be present without being overwhelmed. I made his meals and I sat with him in the evenings, and I read to him when his eyes were tired and I held his hand in the hospital room at the end. This is not remarkable. This is what love does. But it is important to say it plainly, because the narrative that arrived in the boardroom, the narrative of a wife who had been around while the real work happened, is so distant from the truth of those 47 years that naming the distance feels necessary. I waited 4 years after the December conversation. I waited through 2 more diagnosis appointments and a surgery, and a period of remission that we both refused to count on too heavily, and a gradual, quiet decline that he managed with the same determination he had brought to every difficult project in his life. I held his hand in the hospital room where the machines kept count. I was there when the count stopped, and the morning after his funeral, my son slid a tattered envelope across a mahogany table and told me to put my recipes in it. And so this is how 47 years gets measured. So this is what a life of work, of late nights and contracts and tax filings and patent applications, and a marriage made of more shared labor than most people will ever accumulate. So this is what it comes to: a torn envelope and an allowance and a suggestion about a smaller house. Did they really think that was all there was to me? Did they really think their father hadn't known exactly what he was doing? I drove home from the boardroom in the car Gerald had bought me for our 45th anniversary, a black Mercedes that I had told him was too much, and that I had been driving every day since because it was his. It was his choice. And every time I sat in it, I could feel the particular shape of how he thought about me. I drove carefully because I always drive carefully, and I did not turn on the radio because I needed the silence. At home, I went directly to the study. Gerald's study was the room in our house that felt most completely his, the room where his presence was densest, where the air still held the particular smell of him, old paper and the faint ghost of the pipe tobacco he had given up in 1998, but which had soaked into the walls and the bookshelves in the decade before he quit. His desk was a large partner's desk in oak, in the same desk we had moved from the original Whitmore construction office when we'd outgrown it in 1988. 3 drawers on each side, a central drawer across the top. He had polished it himself every month since before I knew him. The middle drawer on the right was not locked. I had expected a lock. I pulled it open and found inside a single key on a plain ring, the kind of key that opens a deposit box at a bank, flat and notched on both sides, and a small card in Gerald's handwriting. The handwriting was the handwriting of a man who had been managing a deteriorating grip for several years. Deliberate, careful, the letters formed one by one, rather than in his old fluid cursive. It said, Citizens Trust on 5th Street, Box 1947. Only you, Adele. The attorney knows. Love, Gerald. I sat in his chair. I held the key and the card for what might have been 5 minutes and what might have been 30. I thought about the conversation in this room in December of 2015. I thought about what he had said, the arrangement for the IP, for the patents. I thought about his eyes when he said it, the particular look of a man who is tired but satisfied, who has done what he needed to do and can rest in that. I thought about the tattered envelope in my handbag. I had not yet opened the tattered envelope. I had put it in my handbag in the boardroom and brought it home and put the handbag on the hall table the way I put it every time I come home. And I had not opened it because I had been waiting, without quite knowing why I was waiting, for the right moment. There was something in Gerald's last instruction to me in the hospital room. The envelope. Adele, don't let them tell you what the envelope is. He had known. He had known they would give it to me as garbage. He had known it was not garbage. I picked up my handbag. I carried it into the study. I sat back down in Gerald's chair. I opened the envelope. Inside was a folded piece of paper, old and slightly brittle, with a pattern of small holes along one edge, the kind of perforation made by a standard hole punch, as if the paper had once been in a binder. Unfolded, it was a single typewritten page, dense with the specific language of intellectual property documentation. At the top, in capital letters, Assignment of Intellectual Property Rights. Below that, in the formal legal architecture of a properly executed IP assignment, was a document that transferred from Gerald Raymond Whitmore to Adele Christine Whitmore, his full and sole ownership interest in United States Patent Number 5,024,411, the Whitmore-Pruitt controlled tension forming process, along with 2 continuation patents derived from it, filed in 1997 and 2004, and one pending application filed in 2018. The document was signed by Gerald. It was notarized. It was dated October 14th, 2019, 11 months before he died. I read it 3 times. The third time, I read it aloud, quietly, in the empty study, because some things need to be spoken to be fully real. Then I called Constance Alder. Constance was 73, technically retired, but still available to me by what she called the privilege of our considerable history together. She answered on the second ring. I told her what I had found. I read her the document, and there was a silence on her end that I recognized as a lawyer doing rapid calculations. "Is it notarized?" she asked. "Yes, a notary named Raymond Holt, Hamilton County, Ohio." "Do you know if it was recorded anywhere?" "I don't know yet. Gerald mentioned a safe deposit box at Citizens Trust." "Go to the box first," Constance said. "Today, if you can. Whatever is in that box is what he wanted you to find in that order." I drove to Citizens Trust on 5th Street that afternoon. The branch manager, a young woman who recognized my name from the account history and was appropriately respectful, accompanied me to the vault. Box 1947 was a large box, the kind reserved for significant documents. Inside were 3 items: a copy of the IP assignment document I had found in the envelope, executed in duplicate and countersigned by a second attorney; a copy of the recorded assignment. Recorded, I saw from the stamp, with the USPTO on October 21st, 2019, 7 days after signing, and a letter in Gerald's handwriting addressed to me. The letter was 4 pages. I read it in the vault room, standing up, because I needed to feel the solidity of the floor under me. I will not reproduce it in full. Some things belong entirely to the people they were written for, but I will tell you what it contained, because it is the essential context for everything that followed. Before I tell you about the letter, I want to tell you about the vault room itself. It is a small room, deliberately featureless. Gray walls, a single table, a chair, a fluorescent light of the particular quality that exists nowhere else in the world, except in bank vault rooms and hospital waiting areas. There is nothing in the room designed to make you comfortable. There is nothing designed to make you feel anything at all. It is a functional space, a space for looking at important documents in privacy, and its lack of atmosphere is the point. I stood in that room and I read my dead husband's handwriting for 4 pages, and I want you to know that the lack of atmosphere was, in that moment, a mercy. The gray walls and the fluorescent light and the featureless table gave me nothing to feel toward, nothing to redirect toward, and so what I felt went directly into me, which is exactly where it belonged. He had known. He had known everything he had written to me in that room was the last significant communication he would make as a man who was still present, still himself, still managing a situation with the particular strategic intelligence that had made him what he was. And he had used that last significant communication to make sure I was protected, not provided for. Provided for was the trust fund with the monthly allowance, the provision that any careful estate attorney would have insisted on. Protected, given the means to stand up for myself. Gerald had known from early in his illness that Richard would move to consolidate power the moment the opportunity presented itself. He had watched Richard's management of the company over the years, with the mixed pride and concern of a father who recognizes his child's talent and is less certain of his character. He had loved Richard in the particular way of fathers for firstborn sons, without illusion about what Richard was. He had known what Richard would do. He had also known something that Richard did not know, that the Whitmore-Pruitt process and its continuation patents were not merely historical assets. They were active, current, and central. In the previous decade, as construction methodology had evolved, the original process, and in particularly the 2004 continuation, had become foundational to a suite of techniques now used across the industry. So several of the company's most significant current contracts contain provisions that either explicitly licensed the process from Whitmore Construction or assumed its use as a basis for project pricing. 3 of the largest construction firms in the country had licensing agreements still active. The patents were, at the time of Gerald's death, generating approximately $4 million per year in licensing revenue that flowed into Whitmore Construction's operating accounts, and which Richard and Thomas had, apparently, counted as part of the company's ordinary income, without looking carefully enough at its source. Gerald had also had Constance and her colleagues conduct a careful analysis of what would happen if the IP were transferred out of the company's ownership. The conclusion was straightforward. Without the patents, Whitmore Construction's most significant current contracts would need to be renegotiated. The licensing agreements would terminate. The company's competitive position in several key project categories would be substantially weakened, and any attempt to sell the company, which Gerald had suspected Richard would pursue, because Richard had always been more interested in the return on the investment than in the work itself, would require disclosure of the IP status to any prospective buyer. The company without the patents, Gerald had written, is worth less than half what Richard believes it is worth. I am sorry to leave you in the middle of this, Adele, but I could not leave you in the middle of it without giving you what you need to be able to stand up in it. You built the foundation of this company. You filed the first tax returns and negotiated the first significant contracts and stayed up at night with the accounts payable while I was on job sites, spending money we hadn't quite made yet. You learned the patent process because I didn't know it. You have earned many times over the right to the structural position I am giving you. Use it when you are ready. Trust your own judgment about when that is. The last line of the letter was not a legal instruction. It was what it was. You were always the best decision I ever made. All the rest was possible because of that first one. Gee. I folded the letter. I put it in my coat pocket. I put the other documents back in the box. I thanked the branch manager. I walked out into the October afternoon. I stood on 5th Street in Cincinnati, in the city we had built something in, and I thought about Gerald in his last months, managing a deteriorating grip and still writing carefully enough that I could read it. I thought about him at the patent office, at the attorney's office, making the arrangement he had promised me. I thought about him at the kitchen table in 1989, pushing the problem toward me the way he always pushed the hard problems toward me. I don't know how to do that. I'll learn, I had said. I thought about the tattered envelope and what it had meant to Richard when he slid it across the table and what it actually was. Then I called Constance again. Now what? She asked. Now, I said, we wait for Richard to try to sell the company. There was a brief pause. Then Constance said, with the particular dryness of a lawyer who has seen everything and is still occasionally surprised by the elegance of a situation, "How long do you think that will take?" "Not long," I said. "He's been wanting to for years." I was right. It took 4 months. The announcement came in February, which was 4 months after the funeral, and 3 months after I had stood on Fifth Street with Gerald's letter in my coat pocket and told Constance to wait. Richard sent me a letter, not a call, not a visit, a letter through his attorney, informing me that the board of Whitmore Construction Group had voted to explore a strategic transaction, meaning a sale, and that this decision was within the board's authority under the company's governing documents. He included, as a courtesy, a copy of the non-binding letter of interest from the prospective buyer, a large private equity firm based in New York that specialized in acquiring regional construction companies and folding them into national platforms. The letter of interest valued Whitmore Construction at $340 million. And I read the letter at the kitchen table of the house Gerald had wanted me to leave for something smaller. I read it twice. Then I called Constance. "They've moved," I said. "I'll start drafting," she said. What followed over the next 6 weeks was the most deliberate thing I have ever participated in, and I have participated in a great deal of deliberate things over 69 years. Constance assembled a team. She brought in an IP specialist from a firm in Washington, D.C., a transactional attorney who specialized in M&A disputes, and a forensic accountant who spent 2 weeks reviewing Whitmore Construction's financials, specifically for the purpose of documenting the precise financial contribution of the Whitmore Pruitt patents and their continuations to the company's revenue and valuation. And the forensic accountant's conclusion: the patents and the licensing revenue they generated, properly capitalized, accounted for approximately 44% of the company's attributed value in any reasonable valuation model. This was not a small number. This was not a rounding error. More important than the revenue was the contractual structure. The IP specialist's analysis, conducted over 3 weeks with access to Whitmore Construction's contract files, identified 11 active contracts that contained explicit or implicit IP dependencies on the Whitmore Pruitt process. Transfer of the company without an accompanying transfer of the patent rights that now resided solely with me, would create immediate breaches of all 11 contracts. Any buyer conducting appropriate due diligence would find this. Any buyer, including the New York private equity firm, which had engaged its own transactional team, and which would, in the ordinary course of its due diligence process, conduct an IP audit. We let the process run. We watched the due diligence timeline progress through February and into March. We watched the preliminary closing conditions get discussed. We watched the New York firm's team arrive in Cincinnati and begin their review of the company's books and records and contracts, and eventually its intellectual property. On a Tuesday morning in March, the third Tuesday, the one I had designated in my own mental calendar as the right moment, Constance filed with the United States District Court for the Southern District of Ohio a complaint for declaratory judgment establishing my sole ownership of the relevant patents, accompanied by an application for a temporary restraining order preventing any transfer of the patents or any transaction premised on the patent's inclusion in Whitmore Construction's assets without my written consent. At the same time, she sent a letter to Richard's attorney, to the New York firm's transactional counsel, and to the board of Whitmore Construction Group, enclosing copies of the recorded USPTO assignment, the forensic accountant's analysis, and the IP specialist's contract dependency report. The letter was 2 pages. The last paragraph said, "Mrs. Whitmore is the sole legal owner of the intellectual property that constitutes a material component of the company's value, and that underlies a substantial portion of the company's current contractual obligations. No transfer of the company, in whole or in part, may lawfully proceed without Mrs. Whitmore's participation and consent. Mrs. Whitmore has authorized us to communicate that she is prepared to discuss the conditions under which that consent might be provided." I was in the study when Constance made the filings. I was sitting in Gerald's chair at Gerald's desk, with a cup of tea that had gone cold because I had forgotten to drink it. I thought about October, the boardroom, the mahogany table. I thought about Richard's face when he slid the envelope. I thought about the allowance and the smaller house in Hyde Park, and the way Thomas had nodded. Constance called me 40 minutes after the filings. "Richard's attorney is on the other line," she said. "He sounds like a man who has received very bad news." "He has," I said. Richard called me personally that evening. This was, in itself, notable. He had not called me personally since the week of the funeral, having communicated since through his attorney or through Thomas. He called at 7 in the evening, which told me he had spent the afternoon being educated about the situation and had needed several hours to arrive at the decision to pick up the phone himself. I let it ring 3 times before I answered, not as a gesture of pettiness. I am not fundamentally a petty person. As a gesture of measurement, I wanted to know whether he would wait. He waited. "Mom," he said. "Richard," I said, "I need to understand what's happening." His voice had the quality it gets when he is trying to perform calm and not quite succeeding. A slight elevation in pitch, a fraction of a second too fast. "What's happening," I said, "is that I own the intellectual property that underlies approximately 44% of the company's value and 11 of its active contracts. What's happening is that your father transferred that ownership to me in October of 2019, properly executed and recorded, and that it has been mine, legally and unambiguously, since that date. What's happening is that you cannot complete the transaction you have initiated without my participation." A silence. "Why didn't you tell us?" he said. "You didn't ask," I said. "You told me to store my recipes in a torn envelope. You explained my allowance to me. You suggested a smaller house." I paused. "You didn't ask." Another silence. Then, "What do you want?" I had thought about this question carefully. I had thought about it since October, since the vault, since 5th Street. I had thought about it with Constance, with the transactional attorney, in the quiet of the study late at night when the river was dark in the distance and the room still smelled of Gerald. I had not made a decision about what I wanted until I was certain that I wanted it for the right reasons, not from anger, not from the desire to punish, but from a clear understanding of what was correct. "I want to be party to the transaction," I said. "I want a seat at the table that reflects the value of what I own. I want the IP either to remain with me as a separately compensated asset in any transaction, or to be included in the sale at its properly assessed value, with that value attributed to me and paid to me accordingly. I want the board composition restructured to include an independent director appointed with my approval. And I want an apology, not a legal document, a real one. Richard was quiet for a long time. The apology, he finally said. You want a real apology? Yes, I said. I want you to understand what you did and to tell me that you understand it. Not because I need to hear the words for my own comfort, because you need to say them for your own sake. And you should have the opportunity to do that before anyone else has to say them for you. The New York private equity firm, when the full picture of the IP situation was presented to them, did not walk away. They were sophisticated enough to understand that the situation was resolvable and that the underlying asset, the company, the patents, the market position, remained attractive. They were, however, required to restructure their due diligence and their valuation model to reflect the accurate IP ownership, and the resulting renegotiation of the letter of interest produced a transaction structure that was significantly different from the one Richard had been expecting. In the restructured transaction, my IP was valued separately at $87 million. The forensic accountant's capitalized value, accepted by the buyer's own independent valuation team. This amount was payable directly to me upon closing. Additionally, I was provided a consulting agreement with the acquiring entity for a term of 3 years at a rate that Constance had structured to reflect the value of the institutional knowledge I represented. The total consideration I received in the transaction that Richard had planned to execute without me, with the torn envelope as my inheritance and a monthly allowance as my provision, slightly over $91 million. The board meeting at which the restructured transaction was approved was held in the 42nd floor boardroom, with the view of the Ohio River and the Kentucky hills. I attended. I sat at the table, the mahogany table, the table where my name had always belonged, and I voted my interests, and I watched my sons navigate the experience of being in a room with a version of their mother they had not known existed. Thomas cried a little. He has always had more of Gerald's emotional availability than Richard does, which is both his strength and his limitation. He came to me after the meeting in the hallway by the elevator, and he said, "I'm sorry, Mom. I should never have let Richard." He stopped, and he tried again. "I should have been better." "Yes," I said, "you should have." I looked at him. "You still can be. That option is still open." He nodded. He wiped his eyes. He is 48 years old, and he still looks, in certain lights, like the 3-year-old with the ear infection. Richard was harder. Richard is always harder. He came to me at the end of the meeting, after everyone else had left, after the attorneys and the advisors and the New York team had filtered out, and it was just the two of us in the room we had both been in many times before, with the afternoon light on the river. He stood across the table from me. He had his father's build and his father's jaw, and absolutely none of his father's ease. "I owe you an apology," he said. It came out stiff, constructed, and the words of a man who has decided to do something and is doing it by force of will rather than by natural movement. "You do," I said. "I treated you as if everything you had done didn't count, as if Dad had built this alone, and you had just been around while it happened." He stopped. "That's not true." No, I said, it's not. I knew it wasn't true, and I acted as if it was anyway, because it was convenient for me. I looked at my eldest son. I thought about the night he was born, the particular quality of that night, the fear and the astonishment and the love that arrived, enormous and unexpected, in the first moment after, and which had never left, regardless of what he became or what he did. I thought about Gerald saying, I could not leave you in the middle of it without giving you what you need to be able to stand up in it. I accept your apology, I said. It's not enough yet. But it's a beginning, and beginnings matter. You know that. Your father built everything from a beginning. He looked at me for a long moment. Then he nodded. Once definitively, the way Gerald used to nod when he had received something and integrated it. I picked up my coat from the chair. I walked to the elevator. I pressed the button for the lobby. This time, Richard Whitmore stayed at the table. But as the doors were closing, I saw him stand up. The transaction closed on a Thursday in May, which was Gerald's birthday, May 14th. And I do not believe this was a coincidence, because Gerald had never in his life allowed an important thing to happen on an unimportant day, and I had scheduled the closing date myself, $91,200,000. I remember the exact number because Constance read it to me from the wire transfer confirmation, and I asked her to read it again. Not because I didn't believe it, but because I wanted to hear it twice. The way you hear certain things twice to make them real. The way I had read the assignment document aloud in Gerald's study. I stayed on the phone with Constance for a few minutes after she read the number. Then I thanked her for 25 years of work on my behalf. And she told me it had been her privilege and that she meant it. And I believe she did. Then I poured myself a glass of the good scotch that Gerald had kept in the study cabinet, and I sat in his chair, and I looked at the river. The house in Cincinnati, which Richard had suggested I trade for something smaller in Hyde Park, is mine. The deed is in my name alone, has been in my name alone since 2012. When Gerald put it there for reasons he explained to me at the time as estate planning, and which I now understand were also preparation for this. The house has a study with a view of the river and a kitchen where I have cooked 10,000 meals, and a garden where Gerald used to sit in the evenings with the pipe tobacco he gave up in 1998. Just sitting in the garden air as if it still held the smell. I kept the house. I am keeping the house. It's what I have done with the money is perhaps less dramatic than some people expect when they hear the number. I have not bought an island or a yacht or any of the things that $91 million can buy if you are interested in those things. I have established a foundation. The Gerald and Adele Whitmore Foundation, endowed with a substantial portion of the transaction proceeds, focused on construction industry education and scholarships for women entering accounting, finance, and the building trades. I have funded a chair in construction engineering at the University of Cincinnati. I have made gifts to several organizations in Cincinnati that Gerald and I had supported privately over the years. I travel. I have been to places Gerald and I always talked about and never got to, because there was always another project, always another milestone, always another reason to wait. I went to Tuscany in June, alone, and spent 3 weeks in a rented house in the hills above Florence, and ate meals that took hours, and looked at paintings that took centuries, and thought about time in a way that I had never quite managed, when there was always something immediate competing for my attention. I am writing this account, in part, because people, women specifically, and often older women in situations not entirely unlike the one I was in on the morning after Gerald's funeral, have asked me to. They have heard the story through the channels through which such stories travel, the quiet network of women who pay attention to each other's situations, and they have asked me, how did you know? How did you hold it together? How did you know what to do? And the answer to all three questions is the same, and it is not a clever answer. I paid attention. I paid attention for 47 years to a marriage and a business and a man who loved me more intelligently than he was always able to show. And I understood, eventually on 5th Street in October with the letter in my pocket, exactly what he had left me and why he had left it the way he did. Gerald could have told Richard and Thomas about the IP assignment. He could have left a clear will that laid everything out. He chose not to. He chose to leave it where he left it, in a tattered envelope, in a bottom drawer, on a key card in a vault, because he understood that what I needed was not just the asset. What I needed was the experience of finding it myself, in my own time, on my own terms. He understood that the process of discovering it and understanding it and deciding what to do with it was itself the gift. That arriving at the boardroom table as a woman who had done all of that herself was different in ways that mattered, from arriving as a woman who had simply been given instructions. He trusted me to be the person he had known for 47 years. He was right to trust me. I think about what the tattered envelope meant when Richard slid it across the table. He meant it as a dismissal, a casual, contemptuous assignment of me to irrelevance. He meant to communicate that the real things, the money, the company, the decisions, were in the hands of people who mattered, and that my place was the kitchen and the recipe box and the smaller house in Hyde Park. He meant all of that, and he was not subtle about meaning it. What the envelope actually was, a key to the most important document in the company's existence, a man's final expression of love, in the form of the most powerful thing he had ever given anyone. A test of sorts, not of my competence, which Gerald had never doubted, but of my willingness to use it, which is a different thing. He had not been certain until nearly the end that I would be willing to use everything I had in my own defense. I was 69 years old, 3 months a widow, sitting in the chair of the company I had built and been written out of. I was willing. My kindness was never a doormat. My silence was never consent. My presence at those dinners and those board meetings and those Christmas card signings and those anniversary celebrations, my whole life of being in the room, but not always recognized as the room's co-author, was not ignorance of what I was worth. It was patience. It was the patience of a woman who understood that the right moment for certain things is not determined by urgency, but by readiness. I was ready in October. There is a word that appears in the heading of this account: control. And I want to spend a few minutes with it before I finish, because it is a word that means different things to different people, and I think the way I mean it is important. When people talk about control in the context of wealth and business, they usually mean operational control. Who makes the decisions? Who signs the checks? Who sits at the head of the table? Richard understood control in this sense. He sat at the head of the table. He signed the checks. He made the decisions about the transaction. He controlled in this operational sense completely, until the moment he discovered that the operational control he held was dependent on something he didn't own. That is the kind of control I am talking about, not the surface control, the day-to-day authority, the visible and performed leadership, the structural control, the control that lives in the documents, in the legal instruments, in the carefully maintained records that define what is whose and under what conditions and with what limitations. This control is invisible in ordinary times. It becomes visible only when someone tries to move something that is attached to it without having it. Gerald understood this. He had understood it since 1991, when the patent was granted and we sat at the kitchen table and talked about what it meant. He understood that the patent was not merely a protection for the process. It was a structural fact about the company, a fact that preceded and conditioned everything that would be built on top of it. He had arranged, with great care and considerable time, to make sure that the structural fact was in my hands and not subject to the dispositions of people who would not use it wisely. I have thought, in the months since the closing, about what the greatest assets in my life actually are. Not the 91 million, though I will not pretend money is not an asset, because pretending would be absurd and also dishonest, and money in the hands of someone who understands what to do with it is genuinely useful. But before the money, before the patents, before any of the external instruments, the knowledge, the 47 years of paying attention to the company and the industry and the legal and financial landscape of what we had built, the relationships, Constance, the accountant, the patent examiner who remembered the original filing, the specific, technical, accumulated competence of a woman who learned the patent process in 1989 because her husband said he didn't know how, and she said she'd learn. That competence was always mine. It was mine when Richard slid the envelope. It was mine on the night I stuffed Christmas card envelopes at the kitchen table with a sleeping baby upstairs. It was mine before the patents were filed, before the company crossed $1 billion, before any of the external validation existed to confirm it from the outside. The greatest asset was never in the bank account. It was never even in the vault on 5th Street. It was in the knowledge. It was in the 47 years of work that nobody could take away because they hadn't seen it and didn't know it existed and hadn't thought to look for it when they decided I was old and irrelevant and good for recipes. And they didn't look. I had spent 47 years in that company, and they did not look. So this is what happens when you don't look. The person you dismissed as the past turns out to be the foundation. The person you reduced to an allowance in a smaller house turns out to hold the key to the vault. I am 69 years old. I live in the house in Cincinnati with the view of the river. I travel to places I have been meaning to visit. I run a foundation that has, in its first year, funded 11 scholarships for women in the building trades, 3 of whom have already written me letters. I sit in Gerald's chair in the study because it is the most comfortable chair in the house, and I read things I have been meaning to read for 47 years. And I think about what comes next, which is a question I find I am still genuinely interested in. I was in Florence in July when one of the scholarship recipients, a young woman named Brianna, 23 years old, from Dayton, starting her first year of a civil engineering degree, sent me an email that I read on my phone in a small restaurant on a cobblestone street, with a glass of wine in front of me and a view of a medieval building out the window. She thanked me for the scholarship. She said she had almost not applied because she had been told by a professor in her community college program that construction engineering was really a man's field, and that she might find it more welcoming to look elsewhere. She said reading about the foundation and about why it had been started had made her apply anyway. I wrote back to Brianna from that restaurant on that cobblestone street. I told her the professor was wrong. Not accidentally wrong, not ignorantly wrong, but wrong with the specific wrongness of someone who has decided what is possible and stopped looking at the evidence. I told her that the people who build things in this world are not determined by what field welcomes them, but by whether they are willing to do the work. I told her to do the work. Then I finished my wine and looked at the medieval building and thought about Gerald, who would have been fascinated by the engineering of it, how they solved the load-bearing problems, how they managed the material constraints of the 13th century, what they would have done differently if they had had modern tools. He would have been standing in the street, craning his neck and talking about tensile strength. I would have been writing it down. That is who we were. That is still, in some essential way, who I am. The consulting agreement with the acquiring firm runs for 3 more years. They call me occasionally with questions about the history of the process, the technical choices made in the original patent filings, the logic of certain contractual provisions that reach back to decisions made in the 90s. I answer their questions precisely and with full context. I charge them my consulting rate, which Constance set and which is not modest. Richard and I speak once a month. The calls are not comfortable yet and may never be entirely comfortable, and I have made my peace with the possibility that some damage is not fully repairable, and that making peace with that is itself a form of resolution. He is doing better than I expected, in the ways that matter. He is more careful, more attentive, more willing to sit with a question before answering it. He is becoming someone Gerald might have recognized as his son. Thomas and I speak more often. Thomas has always been more available in his emotional life, and the events of the past year opened something in him that I think needed opening. He has been asking me questions about the early years, about how Gerald and I built the company, what it was like in the beginning, what I remember of the decisions that shaped it. He is writing something, he says. I don't know what it is yet. I am glad he is writing it. And the tattered envelope is in the study. I kept it. I keep it on the desk in the corner where Gerald kept the things that mattered to him. A photograph of us at our wedding, a small piece of the first concrete he ever poured, a commendation from the city of Cincinnati dated 1985. The envelope is there with those things because it belongs there, because it was the last gift and the most complete one. Someone asked me recently what I would say to my sons if I could say the one thing I most wanted them to understand. I thought about it for a while. Then I said, look at the people in your life who have been quietly building things while you weren't looking. Look carefully. What they've built is probably the most important thing in the room, and if you don't see it, you will only discover it when you try to move something that's attached to it. Then I said, and when someone gives you a torn envelope and tells you it's garbage, Open it anyway. Gerald always said, the foundation is the whole building. You can change the floors, the walls, the fixtures, the view, but what's underneath doesn't move. What's underneath was always there. What's underneath is the whole thing. He was right. He was always right about foundations, and I was always the one who made sure the paperwork was filed.